Good evening. The IWA strike is over, thank goodness. But the cloud of the countervail, the American action claiming that we subsidize our export softwood lumber, still hangs heavily over our heads. Let me try and put it to you simply, because there's been a lot of confused talk about it, where the countervail negotiations now stand. First of all, there is agreement between Canada and the United States, I am reliably informed, on the rate, which is 15%. There is a clear understanding it will be levied by Canada in an export tax, which will gradually be translated into stumpage. And the effect of that will be that the $400 or $500 million which would leave the country to go to the States, to them, will stay here for use in our forest industry. But there are a couple of things that still have to be settled in the negotiations. One, the Coalition for Fair Lumber Prices in the States must lift its application. And two, Canada at the moment has rejected certain aspects of the overall agreement. And the aspects are, to put it quite succinctly, certain bells and whistles which the Yankee traders are trying to hang on to the 15% agreement. Now, these bells and whistles would in effect be a form of the old suspension plan. In other words, accepting the fact that we're going to put up the price of lumber 15%, the Americans still want the right to interfere in the way we handle our forest industry. They want to interfere and say, hey, you shouldn't be doing this, you shouldn't be doing that, you shouldn't be giving this help, you shouldn't be getting that help. And Canada, and properly in my opinion, is saying quite succinctly there will be no interference with Canadian sovereignty on how we manage our primary resources north of the 49th parallel. It doesn't look all that hopeless, so it looks good because there is agreement on the 15%. There's agreement on the export tax to be transformed into additional stumpage. But what Canada will not go for is any form of that suspension caper, whereby they can look over our shoulders all the time and say, we don't like you doing this, we're going to up the 15% to 18% or 20% or 30%. So Van der Zalm is right when he says there is agreement in general, but there are a number of tricky things that have to be fixed up. The principal one being the lifting by the Coalition for Fair Lumber Imports, and the second one being no bells and whistles to allow them to monitor or police our industry. With any luck at all, it will be solved soon. If it's not, we're back at square one. That's the simple Webster explanation of countervail, which you should be able to understand. Now for the rundown.
Kids in court. If they are victims of abuse, their testimony cannot stand alone in a court of law. But that may change under a new bill aimed at tightening the laws against sexual abuse. In the studio with Webster, lawyer Wendy Harvey, and Fran Grunberg, sexual abuse counselor. But first, what will happen to BC's lumber producers if prices are forced up by the Americans? The biggest chunk of softwood exports to the United States comes from BC, and one group anxiously awaiting a deal with Washington is the Caribou Lumber Manufacturers Association. And Whitey Anderson from Williams Lake is up first with Webster.
Little story. About a week ago, this man here, Whitey Anderson, of the Caribou Lumber Manufacturers Association, Jacobson Brothers Forest Products Limited at Williams Lake, came to see me and said, I want to go on the air with you. I said, why should you go on the air with me? He said, all you ever do is talk to the big boys down on the coast. What about us, the heartbeat of the entire lumber industry in central British Columbia?
Correct.
Whitey, tell me about your own operation first, Whitey, Jacobson Brothers. You a big outfit?
Oh, we think we're little in the BC scheme of things. We do about 180 million board feet a year, employ about 200 and odd people in the sawmill, another 200 or so in logging and trucking.
And Caribou Lumber Manufacturers Association covers 27 or so operations.
That's correct.
How much of our softwood lumber would be exported by the people in your association out of central BC?
Roughly the amount of wood that goes in the United States from our area is approximately 80% of the total production from the area, which is roughly 2 billion board feet.
You send a large chunk of our exports.
You bet. More than probably any other association or group in the interior.
And you're the people who've been getting away with murder on minimum stumpage, aren't you?
You're the one that said that. I'm not saying that because our stumpage has been fair and equitable over time.
Now, just let's put stumpage.
Yeah.
Stumpage is what you pay me, the taxpayer, for taking my trees.
Correct.
Is that correct?
That's right.
How much do you pay me on 1,000 board feet or a cunit of
Well,
that
when the market
wonderful
is-
softwood lumber you export in these long dimensions
Well,
to
for
Chicago?
trees that are about that big, Jack, as opposed to the ones on the coast this big, and we don't want to get into that, but we measure the value of the products you can make out of that. And we pay approximately $5 per 1,000 board feet if you want to put it into 1,000 boards, as opposed to the, the new buzzword is metric now, and it's cubic meters. So,
$5, that sounds pretty cheap to me.
well, it's only just one small part of the total cost picture, though, Jack. You add stumpage and forestry costs, and you add roads and trucking, and you add logging, and you add sawmilling. It all one part of it that adds up to a big cost picture.
Okay, you had my little homily on the countervail, and you understood what I was trying
Yes,
to
I
say,
did.
didn't you?
Very succinctly, by the way.
There is going to be some kind of countervail, it would seem, because if this all collapsed, which we don't think it will, the Americans apparently would still want their 15% tax, right?
Right?
You could absorb that and not even notice it. Am I correct?
Absolutely incorrect.
What do you mean?
Absolutely incorrect. That 15% will be straight added cost. There's no such thing as absorbing it. We'll absorb it if the market is high enough and we're driven by the market. And all that will mean in the long run, as sure as I'm sitting here and you're sitting there, that when this market, we're cyclical, our markets go up and down over time. You know that, I know that, and I think the general public knows that too, that when we get a downturn in this market, quicker now, because of the 15%, people are going to drop out and have to close down. It's going to affect people, basically.
How much money did you make last year?
In 1985?
85.
We just made a slight profit in 1985.
How about 86?
86 is going to be a good year, and I think it'll be a good return on investment, and we're proud of that.
You're talking about the Caribou Lumber Manufacturers Association as well as Jacobson.
Yes, yes.
But tell me, how much did the strike hit you? Or most of your mill, you're non-union, your own mill,
We happen to be non-union, but
Right.
most of the mills in the Caribou are union mills.
right? And how much did the strike hit you in terms of production?
In terms of production, it didn't hit us in the interior at all. But what it did do, it took a heck of a lot of lumber off the market, so that when we're looking at the industry today, it's quite easy for one to sort of say, gee, they're doing great, but it's an unrealistic perception. A lot of lumber onto the market didn't occur because of the strike.
All
Pure
right,
and
now
simple.
that the strike is over, what's that going to do to your markets from the Caribou or to the price of lumber?
Oh, almost immediately that they made the settlement. There was a reflection in the futures market right away. And right now, all of a sudden, the buying stopped. Order files, if you had lucky enough to have an order file out for 3 or 4 weeks, are secure. But beyond that time, people are having difficulty because no one really knows now what's going to happen. They're waiting.
How about the overall effect of the 15% added costs under the countervail or some equivalent of the countervail? It's going to hit everybody, is it?
I think it would hit everybody to a degree. It will hit those ones, though, that have timber of poor quality, that's farther from their sawmills, and they're further from the market of the United States. They're going to be the first ones, Jack.
But you know that it was your boy Bill Van der Zam and Jack Kempf who volunteered an increase in stumpage early on in the negotiations. How did you feel about that when they were in effect saying, we plead guilty, we're going to add we're going to add to the stumpage here so that the people of British Columbia can get a fairer return for their irreplaceable resources? How did you feel about that when they pleaded guilty on your behalf?
I guess it's safe to say not happy. But then again, on the other side, there were people telling us, counsel in Washington, that were closer to the political scene than we were saying maybe the route we should go with, because it's political, this whole protectionism from the United States, perhaps we should try to strike a deal. And there were people telling us that.
But Zimmerman
But we
was-
were still saying, all of us in industry are pretty well unanimous on that one.
No
is that
deals.
no deals. This is hard.
Let them make their
burden.
decision and slap a tax on if they must, because you and Zimmerman and company, APSI, were pretty confident that on the technical face of it, you could beat the whole countervail.
Yes, and we still feel that as far as the technical feel.
Well, it certainly
basis
looks
is concerned,
tonight now like there's no way. Somebody must know that there's going to be a 15% countervail or its equivalent.
That's correct. That's correct.
Now, people on the lower mainland who've seen a lot of the side hill logging shows and the nasty, ugly scars throughout the province of British Columbia tend to feel that you people don't clean up. You don't look after your silviculture. You leave a lot of waste in the woods.
I think that, again, I had a list of myths
Well, give me
that
the
I
myths.
call, and that's one of them, that forest management, in a sense, is in shambles. People feel that way. I'm really concerned, two things, though. I'm really quite pleased to hear people now speaking about forestry. Never did for the last 30 years. Now they are. And what that's doing is waking us up to say, hey, what are we doing? Number one, we're not telling the public. You blasted us in Ottawa. You people in
Oh, the
industry,
Forestry Congress.
That's
And that was
right.
right. I said there wasn't one decent spokesman for industry in British Columbia that the media could use to tell your story properly.
That's right. And it's difficult to tell the story in an audience, in a room, or in an office. Where we tell the story out in the woods. There's a lot of good going on there. And
Do you people care about silviculture or tree planting?
Absolutely, and we do lots.
And you have very easy logging conditions. You don't have the big expensive logging conditions they have on the coast.
We have some of the steep slope logging because we border up against the Cascade Mountains, and so we have some steep slope. But in general, we have easier terrain than the coast. That's true. But we have the other side of the coin is we have small trees that are only capable of producing or making dimension-type lumber.
They're so easy to log.
They're much easier to log than on the coast.
And you
that's
don't have
true.
to build fancy, heavy roads.
Our roads are are pretty tough.
Well,
in
what
some
would you
places,
say to the
Jeff,
average person on the lower mainland who listens to likes of Webster, that we are misinformed and we don't tell your side of the story?
What do I say to people that say
Do you
that?
believe that we misinform people and we don't tell your side of the story?
No, as a matter of fact, you did an article last year on Lyle Island, I believe, and I felt you did an excellent piece of work on that, getting both sides of that story. You do a good
I
job.
got
there.
them the logging permits, and look at the trouble it caused with the Haida Indians.
That's true. But I do think it's safe to say, though, that some of us poor little guys from Williams Lake kind of think that the people on the coast view Vancouver's ending about hope.
I know. The province is ending about hope.
Yeah,
Okay, if you have any quibbles to make with Whitey Anderson, it's O.J. Anderson,
Correct.
Whitey Anderson from Williams Lake, and all these Caribou Lumber people, call him now. Give him a bad time if you want to, after the break. What the Americans probably want to do, Whitey, is to monitor our industry in such detail, if they got away with this suspension technique, would be to come up and say to Jacobs and Brothers, hey, you got a reduction in power because times were bad. We're going to up your tax. Is that the kind of thing you think they want?
I suspect so. They want to monitor exactly this 450. That's for BC. 600, I guess, in Canada. I think they'd insist upon that.
We shouldn't allow them to do that, should we?
But then shouldn't we do that to them? Shouldn't we go down and monitor their system then too? You know, they got a lot of glitches in their system, Jeff.
A lot of gall, too. Go ahead to Whitey Anderson.
Yeah, Mr. Anderson, so far as this forest management is concerned, you never answered the question properly earlier. How much do you spend on reseeding the forest in proportion to what you take in profit?
Just a minute. I don't know if we're right in your ball field. You're here for the Caribou Lumber Manufacturers Association.
Yes.
Do you have a tree farm license?
No, we have a forest license. And most of the tenure in the Caribou is forest licenses, which is not land-based, like a tree farm license. It's volume-based.
Now, did you get permission to cut so much in a certain area?
That's right.
Who replants it?
We do the planting. We do the physical planting of the area. In the Caribou, I speak for the Caribou
Yeah.
only here.
Yeah, but doesn't he subcontract that out to subcontract tree planters?
Yes, we do.
Okay, so how much do you do in proportion to...
What you cut.
Yeah.
To what we cut, we're planting and treating approximately 50% of the area that we log. The other 50% comes back naturally.
Okay, that's volume, but let's talk dollars and cents. How much do you spend by hiring these subcontractors?
Okay, last year we started planting I really hesitate to get down to just our company. but if you want to know just our company, I don't mind answering that. We started planting in 1970, and we've been planting every year since. And last year we planted approximately 2 million seedlings, in our case, and that cost ran around the $300,000 mark.
Now that comes off your stumpage as a cost of forestry, doesn't it?
Doesn't particularly, that's a misnomer that it comes off stumpage. They only use the revenue that comes, that portion of the revenue that we send in order to pay us back for doing the work for the landlord. We're just doing the work for the landlord in that case.
You did 2 million seedlings last year, was replanted, half the land get logged.
And that runs in the Caribou area, that's pretty well typical. About 50% of the area doesn't come back on its own.
And what was that yearly cost again?
$300,000
in our case.
Per year, eh?
That was for that one
yes.
company. Thank you. Got to keep going. You'll be here all night. Go ahead, please.
Two questions to Mr. Anderson. Jack, first thing, Mr. Anderson says that the Caribou forest producers are in general agreement with the industry on fighting this 15%. Well, now today we hear that John Kerr, or Jake Kerr, I'm sure Whitey's aware of him, has resigned from the Canadian Forestry Council in a dispute with Adam Zimmerman on the industry's position. So I don't see that there's too much unity there, and I want him to answer to that one. And the second point is, Mr. Anderson makes this claim about how there's all kinds of costs that the Americans don't take into consideration, such as road building, et cetera, et cetera. He calls this one of the myths. Well, maybe Mr. Anderson can explain one little thing to me, and that's a little section called Section 88 in the Forest Act, alongside TFLs and monopolies and the industry being in bed with the landlord, as he calls it, et cetera, et cetera. Maybe a clear explanation of Section 88 and what these guys can write off, which basically turns the forest industry in this province into a cost-plus operation. It's one of the biggest scams, and it's just a disgrace what's been going on here. And as for you, Jack, I think it's more power to the Americans to be looking over our shoulders to see how we're running this operation up here. These guys have been getting away with murder for the last 35 years in this province, thanks to inane administrations by the social credit party these guys are in bed with.
Well,
I'd like them to answer to.
Well, you can't expect them to go through all that hyperbole.
Now, listen, this is stuff that should have been coming out a long time ago, and Jack, you with your shares in Western Pulp and et cetera, you should be a little harder, too.
What shares in Western Pulp?
Well, you and that Dome and Western Pulp thing.
I sold them at the moment I realized it.
You can do all the things you want. You've got a little bit of a stake in this, too.
So everybody has.
Yeah, that's right, Jack. So let's get to the point here.
Okay, boy.
John Kerr's resignation today.
Who? Jake Cares?
Jake Kerr from Lignum Sales. You guys all know him. I'm sure you've been notching it up with him, too.
Jake Kerr obviously fell out with Adam Zimmerman's adamant attitude that he would have no negotiations at all with the Americans and was prepared to rely on the success of the countervail 3 years ago and thought it was coming back again this time. And the politicians...
It kind of flies in the face of what Mr. Anderson just said not 2 minutes ago about the Caribou Lumber producers being in agreement with this position.
I don't think they are.
Well, then what's Jake Kerr doing resigning
Well,
from
you ask Jake Kerr. I don't give a damn what Jake Kerr's thinking tonight, to be quite honest. Some of these callers are quite cheeky. Go ahead from Alberni.
Hello there.
Yeah.
I'd like to talk to your visitor on what he was saying just a little while ago, that they do not waste in the forests. I'm a hunter, and I've been all over BC, right from the north end to the south side, the east side. Now, in most places that I have been, I have found more waste in the forest than enough, and I think that if they were charged more on stumpage, they certainly wouldn't leave that waste in that forest.
There's a lot of stuff left in the woods, especially on the coast, but I don't know if they're so bad in the interior.
Oh, no, we're good in the interior. And I even say that I've been, yes. As a matter of fact, if you increase the stumpage, what can really happen is you may leave more in the bush because there may be a tendency, which we found out years ago when we used to bid for the timber and the bids were way high, then high grading really went on. And quite frankly, we just don't condone that.
Okay.
Okay.
Bye. Go on to the next one. Go ahead from Glasses. Fort St. John.
Yes, sir, Mr. Webster and Mr. Anderson. I'm just wondering, do you think the price of wholesale lumber will drop 15% before it goes south to markets, therefore still being retailed, same affecting the wages and dollars spent in BC and not really raising the price in the States, which is what the American producers wanted?
Would you just, I didn't quite get exactly what your question, would you repeat that, please?
Okay, I'm just basically wondering if the price of lumber will drop 15% now before it goes south to the States, affecting wages and dollars spent in BC, and not really raising the price in the States.
Well, I think that
It will be strictly market-driven. The demand for the wood will
controls the
control
price.
the price purely.
But there's no doubt, though, that we went from a 19% share of the American market to 33% share, and that they need 25% of the softwood lumber from us. And if they get smaller quantities, surely the price will go up a bit in the States.
Oh, it'll go up in the state, and it'll bring on some mills down in the United States. I don't know that the general public really know this, but the United States, over a 13-year period in their lumber industry, has done better than BC.
Not on the West Coast, they haven't.
Yes. If you take the total...
That's because they were able to smash unions and cut the wages $4 an hour. You must concede that's part of it.
That's part of it, too. But if you took it over a long period, in which we just did, a study that covered 13 years, Jack, they've done well.
Good. Go ahead, please.
Mr. Anderson is correct in recognizing that our price for lumber is market-oriented, whether it be the United States or the rest of the world. But part of the costs of selling, or part of production, pardon me, are stumpage. And I thought he said earlier at the beginning of the program that the actual cost of stumpage was $5 a thousand on average. Is that correct? And if so, I have to contend it's awfully low.
Yeah, you could come to that conclusion, but that's only one part of the total cost. They value that. It's a value of the product you can make out of a tree. And in our particular area, we have trees that take 200 stems to put on a truckload. And it also takes into consideration the distance of haul.
But a significant portion of those stems you're putting on a truckload are being chipped up for pulp anyway.
Yes.
And that's part of the design of the operation, so therefore...
That's correct.
You're talking about strictly a production of lumber. The fact that the government is collecting a minimum of $5 a thousand has got to be rock bottom.
And don't forget, too,
that
the stumpage for pulp is even less than that for softwood, is it not?
Well, right now there's virtually no roundwood logging in the interior of British Columbia, Jack. It's all residue from the sawmill in the form of
Kemp
chips.
seems to think it's time for a review, and he was a logger of some kind sometime in the past, so you're going to be dinged for more stumpage and better use of the trees. Trouble is, we keep talking about it, but we never do it.
Yeah, well, of course, I'm a taxpayer as well as a interested observer, and if all the government's collecting is $5 a thousand, somebody is being subsidized, wouldn't you say so?
Yeah, but I think no, I don't think so. You know, I'm glad you raised this question because everyone says stumpage is too low. How do you measure it? How do you measure? You measure it because you go and you go and look at the industry.
The trees is nothing to the forest producers except the cost they put into harvesting.
Well, every single cost is something, and we are concerned about every single cost, whether it's high or low. Or,
well, we're getting too confused now, and I exercise the right to cut in and thank Whitey Anderson from the Caribou Lumber Manufacturers Association for giving us a taste of a point of view from the interior. We didn't solve the problems of the world, but we'll let people know that you're alive and well and still shipping billions of feet of softwood to Chicago and the eastern seaboard of the United States.
And I'm very pleased to be here. And would you come and visit us sometime next year, Jack? We have a good golf course in Williams Lake.
Maybe. We'll see. Providing I can get $5 a thousand stumpage for myself. My thanks to Whitey Anderson. Next, a very serious topic about sexual abuse of youngsters. After the break. Such an old chauvinist.
You are, but deep down.
I'm not.
Great.
I don't keep Dennis happy.
Yep.
You're former director of the Child Abuse Team in Vancouver.
That's right.
There only was one.
No, there were two. There was one in the Fraser Valley as well. Both
Thanks, Jim.
were disbanded in 1983.
By Gracie, baby.
Yeah.
She always used to say there was only one team. Not just
No, there were two. They performed the same functions. The Vancouver team was started first.
hell of a good book.
Thank you, Jack. It's been a good response to it.
It really is very good.
What's happening through the book is that actually there's some very innovative approaches to presenting children's evidence. And they are, in a way, sort of monitoring the process by having their own little book and informing prosecutors on how to prosecute their cases. Thank you very much.
15 seconds, Jack.
One of the great problems in the prosecution of sexual abuse cases involving young children is who testifies, how they testify, what the courts will accept and what they won't accept. But before I get into that tonight, I want to talk about Bill C15, which is properly an act to amend the Criminal Code and the Evidence Act in regard to sexual offences against children and adolescents. And I'm very lucky because tonight I have Wendy Harvey, a lawyer experienced in these complex matters, and Fran Grunberg, the former director of the child abuse team and an MHR counsellor on sexual abuse. Maybe we should explain, first of all, what C15 does basically about the age of sexual offences.
I think what it is doing is acknowledging that kids under 14 do not have the ability or capacity to consent to sexual activity with an adult. And so it's sort of couching that philosophy in legalistic terms.
It says here it would repeal the crime of statutory rape, intercourse with a girl under 14. Is that correct?
That's right.
And there are a number of new sexual offences.
Mm-hmm.
What are they?
Well, they're not new in the sense that we've been living with them in Canada for a long time, at least the facts. But the point is that they're sort of defined a little more clearly now, which is good for everybody. They are sexual interference, which basically talks about touching children in a sexual way. And the other one is invitational touching, and that is, say, encouraging a child to touch an adult. And the other one is sexual exploitation, which talks about a situation where there's a position of trust, and a child is under 18 and there's sort of sexual relations.
Oh, where an adult with authority imposed themselves sexually on a youngster, that would become a specific offence. Was it an offence prior to this?
In some cases not, because the sexual assault section that dealt with it, it talks about consent under 14, but if the child was, say, over 14, unless, of course, it was sexual intercourse itself. But for some sexual activity, it wouldn't have been considered.
Now let's talk about child abuse from your point of view, Fran Grunberg. Are we making any progress in the handling of child abuse as a community? And what do we do about, how do we handle children who have to testify?
I think we've made a lot of progress, Jack, particularly in the area of sexual abuse. It really has only been in the last 5 or 6 years that sexual abuse has been identified as a major social problem. In Canada, we now have the Badgley report, which was an extensive piece of research done in Canada, which says that approximately 1 in 4 female children and 1 in 6 male children will experience some form of sexual assault before they reach the age of 18.
1 in 4 women, 1 in 6 girls and boys.
Right.
What's the average age of the first assault?
The research shows that the average age is usually between the ages of 5 and 9. That's the most common age when it starts. Although there are victims younger than 5, and there are many victims who are older than 9.
Now, you've put out a book which some people might want to get if they're ever in the position. So you have to go to court. A Child's Guide to Testifying as a Witness in Child Abuse Cases, right?
That's right.
And it's an excellent book on what happens in court and what children have to be prepared for.
Thank you, Jack.
Does Bill C15 make it any easier for the Crown to use testimony from children which otherwise would not be allowed under the old rules?
Okay, should I talk a little bit about the old rules?
Yes, please.
Okay, there's the problem in the past in getting kids to court and to tell their story is that we have a rule that before a child is allowed to do it, to give their evidence, they have to convince the judge that they're intelligent enough to do that in the first place, that they understand the duty of telling the truth, and thirdly, that they understand the nature of the oath. There's no point in taking an oath unless you know what the heck it's about. And the child can still testify if they satisfy the judge on the 1 and 2 points I made, but no accused person would be convicted on the basis of that child's evidence alone.
In other words, that child, if the child was decided by the judge as fit to is able to
Sufficiently
tell the
intelligent.
truth, sufficiently intelligent,
Understand the duty of telling the truth.
without corroboration, there could be no conviction.
That's right. And so what happens is that the judges listen to a 4 or 5 or 6-year-old, if that's the scenario, and says, okay, I believe what you're saying 100%, but I can't do anything about it because technically I have nothing over and above what you're saying to convict this person.
He was precluded from
He was precluded. And so the Crown, of course, are saying, well, heck, I'm not going to take this child through this, knowing that we're not going to get it.
So therefore, mother and father and concerned people would put the child through all kinds of examinations by a child abuse team.
Right.
And when they got to court,
It would be thrown out.
all that wouldn't go to court.
Right, right.
Now, can you give us any encouragement? First of all, I can see the need for corroboration in many cases, but surely not only first-hand evidence constitutes corroboration.
No, the other point I want to make is that BC really is in the forefront in terms of kids in court. There are children as young as 3 years old who have testified even without this bill, okay? But unsworn, so that means that there has to be evidence over and above theirs. The average age of children being sworn in BC, that means that an accused person can be convicted on the basis of their word, is the average age is about 7 or 8. Okay, so the judge asks the necessary questions and is convinced that this child understands the nature of the oath. Now, what the bill does is that it suggests that there must still be this inquiry, that the judge must still satisfy certain tests in his or her mind, but that if the child is not sworn, they testify promising to tell the truth, and then the bill is silent on what the difference of the two points are, so that we're sort of assuming, well, what that means is that maybe the evidence is to be dealt with slightly differently because it's being presented differently, but what is that going to mean? Are they going to be asking for corroboration or what?
In other words, Bill C15 is going in the right direction and appears to lean towards the fact that an accused person could be convicted on the word of a child on sworn testimony.
On the face, that's what it
On the
looks like.
face of it. But the new bill doesn't spell it out that the conviction can be obtained.
That's right.
Now, supposing I want to give you what I asked. In fact, I read it in the material here. Supposing a child goes through some horrendous experience, right? And the first thing she does is go straight to her mother and say, Mummy, this, that, the next thing, perfectly horrible. What happened to me? This, that, and the next thing. Can the mother testify?
Well, she will testify to, and this is something that people have trouble understanding. She will testify to, my daughter came to me, she was upset, she said, and she has to stop there. And then, as a result of what she said, I did
certain things.
Right.
Instead of which the daughter might well have said, so-and-so did this and that and so to me.
Right.
And that time when you'd be sure that the child was telling the truth, wouldn't you?
Well, there is an area of law that does allow that type of evidence under certain circumstances, and it's another thing that we're going to have to test more and more as more children come forward. Because certainly in murder cases where people have made complaints, and there's one recently, Henry, in the BC Court of Appeal,
Right.
where it was several hours after the incident that a complainant was talking about a sexual assault, and that was considered the res gestae. But the trouble with child sexual assault is that we've got two problems. You're dealing with children, and we live with all kinds of myths about children and their credibility. And number two, it's sexual offenses, and we live with a lot of myths about the sexual offenses.
More with Wendy Harvey and Fran Grunberg, and your telephone calls too in a little while after the break.
More disclosures.
Fran Grunberg and Wendy Harvey. Now, I'm not fully informed in all these things, but I thought that you people had developed techniques whereby you could interview a child on a videotape, or you could demonstrate with dolls, which later became useful for evidence in court. Is that on or not on?
It's happening in some jurisdictions, Jack. I think there are some courts that are allowing that kind of evidence to be brought in, but it isn't happening right across the board. It's certainly an innovative approach to getting the
Is it mostly
information
used
from
just by
children.
social workers to find out and then not
Right
used
now,
in court?
that's a very common practice.
It's just often in family court more. You know,
Yeah.
like if you have the, because we have the Hopkinson decision, the social worker now can testify in family court, but the listeners have to keep really clear in their mind that we're talking about criminal court where people have been charged with criminal offenses, and it's there that hearsay evidence is not admissible. So the
In other words, if a father is accused of assaulting his own child, such evidence involving dolls could be presented in family court, but he wouldn't be convicted of that offence.
it's a separate court.
And now it's only the family court jurisdiction. And these dolls, for instance, and the testimony of a social worker can't be used in a criminal court on a charge of sexual abuse.
We are using it more and more because I think everyone is recognizing that some of these old rules that we've been living with for centuries in the criminal system just don't quite accommodate the problems that children are facing, and particularly child sexual assault problems. So, for example, there are certainly cases where children actually come and testify, and when they find themselves in a bit of a difficulty, are presented with a set of dolls. In fact, there is a set of dolls in every Crown Counsel's office throughout throughout BC now to assist.
What about this other problem? Many people will say quite properly, you know, children after a sexual abuse case tend to use their own somewhat fantasy imaginations. Can you as social workers decide what's fantasy and what's fact, do you think?
Jack, my experience and the research to date supports the concept that children don't make up these stories, that it's very rare that a child will fantasize or set up a situation which really didn't happen. Children who do disclose about being sexually assaulted are really facing a great deal of trouble. They know that, they've been told that by their offender. So for them to tell is a great risk, and it means that they are going to probably be in a lot of trouble. And children don't lie to get into trouble, they lie to get out of trouble. And so on the whole, children tell the truth about what happened to them if they are sexually assaulted.
Right at the moment, therefore, it almost must be impossible to lay charges against the molesters of very small children unless it's an eyewitness.
Eyewitness or medical, okay, if the child's pre-verbal, you've got a real problem.
Pre-verbal,
right?
can't speak.
That's right, you've got a real problem. You've got a situation where you've got to have someone walk in, which doesn't usually happen, of course. Now, if the child is verbal, the one thing that's happening, you know, the whole business is kind of like a chess game, and all the pawns are moving forward, changing the scenario. And one of the changes is that the definition of cooperation has changed considerably recently.
It's not nearly as strong as it once was. But you're still not too happy with Bill C15 on that, are you?
No.
Or are you?
No, I see Bill C15 as a very positive step to something that has to make a lot more changes than Bill C15. I think it's a very significant endorsement of the problem in Canada. It will provide some ammunition for Crown in introducing innovative techniques and you know, having children give evidence.
Might in effect allow the courts to give the child's testimony of the same weight as an adult's?
Well, the bill doesn't say that, but I see it as a step for what we will ultimately decide should happen in our country.
It's progress,
It's in a field that really was only identified a few years ago. I think we're making great strides.
Well, I'll tell you, I want to go to phones. Go ahead, please.
Yes, hello, Jack.
Yeah.
Yes, I'm very glad to hear that perhaps it may be a lot easier for children to give testimony in court because, after all, sometimes they are the only witness to an abuse. And they are given more credibility. I think that's excellent, and I very much agree that they do tell the truth. Children, especially young children, do tell the truth. My question to Wendy Henry. Wendy Henry?
Wendy Harvey.
Harvey, I'm sorry.
Harvey.
My apologies. Ms. Harvey, I also, by the same token, feel that because the child may be the only witness to the abuse, I also feel it is very important for the child to testify in the case where there has been alleged abuse and no abuse has occurred, because obviously the child would be the one to know whether or not she was abused.
You're talking about, say, a relative's false allegation against a father.
Exactly. And this is true. This is the situation in my case. Now, concerned about, I've been trying to have my children, who are now ages 5 and 6, testify in court. Now, this has gone through family court because they obviously...
Well, look, I don't want to, I must be quite brutal with you. I do not want to go into the particular matter in your particular case, but let me ask you, Wendy, if there's a family court matter where an allegation has been made, the child would be seen in the family court, presumably.
Well, no, they're not, because the idea is that family court is a place where we resolve issues around children abuse. So let's not provide a forum that abuses kids in order to resolve that issue.
But that might be the only way to get justice for the father who's been falsely accused.
Well, the courts have decided that protection of the children is the ultimate issue, best interest of the children, and having the kids testify in family court is not in the best interest of the children.
Thank you. More after the break. Wendy Harvey and Fran Grunberg, and we're talking about Bill C15, which changes the rules in many ways when it comes to sexual abuse of young people. No, young children, I'm going to say, not young people. Go ahead, please.
Hello, this is Jack.
Yes, ma'am.
I'd just like to thank Wendy Harvey for helping my daughter deal with courts and what had actually happened to her back in '82.
Well, good. Thank you very much for the call. Go ahead, please.
Hello?
That's you, ma'am.
Hi. I've been going through a court case myself just recently, and it's very hard for me, and it's very hard on our family.
Uh-huh.
And right now, we have to go for our next hearing, and it's very hard for a person to be up there while the defense lawyer is picking at you, and I really don't... It's very hard for somebody to go through.
Well, I don't know what we can say to you on that, do you?
Well, I'll give an example of a case that I think, you know, I hope I don't lose my credibility because it is a little bit innovative, but I'll give you an example of a jurisdiction in the States, Colorado, where a 3-year-old was found in the bottom of an outhouse where her assailant had left her to die after sexually assaulting her. The way that trial was conducted was a psychiatrist did all of the questioning of the child. And he received questions electronically from the judge, the prosecuting attorney, and the defense lawyer. And the psychiatrist, of course, being a specialist in child development and sexual abuse, and it goes on, was able to frame the questions in a way that would reduce trauma to the child or not create any trauma.
And the child wasn't in court?
No, well, no. There was a room where the lawyers, the judge, the accused sat. There was a one-way mirror situation, and the child was in another room just with a psychiatrist. And it was a classic example of how cross-examination can be conducted in a way that doesn't destroy little people.
And nobody could quibble about the lack of fairness. Defense had the questions.
Right.
Crown had his questions,
That's
the
right.
judge had his questions.
That's right.
Jack, in Israel right now, in the court system, they are using a method by which the child talks to a special person, a special interviewer who has credentials, and that interviewer goes into court and gives the child's testimony. So the child need never face his or her accused and need not be in the courtroom.
But you can see how that shatters the old system of being allowed to face and question your accuser, doesn't it?
The right of confrontation. There is case law in Canada that says that we don't have the right of confrontation because we don't have the Sixth Amendment here. But and that is something that we're going to have to face with the bill. You see, the section concerning removing the accused from the courtroom is going to be challenged under the charter. Obviously, there's a section for that.
Oh, which says so that the accused can be removed from the courtroom in Bill C15.
That's right.
To allow the young person, the child, to give its evidence without being terrified.
That's right.
And that's in there.
That's right.
And that will promptly be charged under the
I expect
charter.
that will be the first one.
And the charter will probably win the day on that one.
I don't know. There's, as I say, there's case law that says that that principle doesn't necessarily apply in our
But
courts.
just as an aside, we don't have the Fifth Amendment or the ludicrous things that are going on in the United States just now where people refuse to answer questions.
Right.
By the way, on that point where he's removed, he still views the trial on closed-circuit TV. So
he's not denied the
no, he's
knowledge
not
of what's
denied
going on.
the
That
knowledge
sounds
of what's
good.
going on.
Innovative is the word to describe these things, isn't it? Means somebody had a good idea. Go ahead, please.
Yes, I'm a foster parent, and I have a 7-year-old girl who has to testify in court. You basically answered some of the questions in regards to the pressure that they're put under. I was just wondering what protection is there for the child in the cross-examination at the moment.
What protection is there for the child in cross-examination at the moment?
Sir, confusing on the cross-examination of a 7-year-old.
All right. The best protection that I know of is preparation of the child to be able to develop her own coping mechanisms, not to be confused by the process, that type of thing. And that's why I strongly urge that proper preparation be conducted. Once the child is in court, it is true that the Crown does not have a lot of say about what happens. It depends very much on the chemistry of the courtroom, of the case, the actors who are involved. However, no defense lawyer is going to get very far harassing a child, particularly in front of a sympathetic judge or jury. And in the event that something is done that the Crown prosecutor or Crown attorney does not like, they of course can object to that throughout the testimony.
Yeah. Thank you very much indeed. If we missed any points, that point on the charter was a good one. And C15 doesn't mean that the sworn testimony of the child can be accepted without corroboration. You hope it can.
The sworn evidence
the
or
testimony.
unsworn?
Unsworn.
No, it doesn't. Well, we are hoping that's what it's saying, but it doesn't set it out very clearly.
Corroboration needs, or the lack of corroboration needs to be spelled out more in C115.
That's right.
Good. Next question. Go ahead, please.
Good day, Jack.
Hi.
I would just like to know, like, if a child comes home and tells his parents that he is sexually abused, and it goes through the court systems and the media gets a hold of it, right? I would like to know, and they prove the child, also the child is proven wrong, can the guy that is getting charged then turn around and charge the parents or whatever?
No, only you can charge somebody, perhaps. I should leave this to Wendy.
I want to ask Mrs. Harvey that.
Mrs. Harvey? You're talking about a false accusation.
Exactly.
Charge laid, accused, acquitted.
That's right.
Yeah.
Well, the trouble is that my experience tells me that just because there's an acquittal, it doesn't necessarily resolve the issue. In other words, there's people who are have committed the acts who are found not guilty. And certainly in a situation like that, it would be clearly inappropriate for anything to happen to the people that are making the allegation. However, if it is very clearly a false allegation, there are provisions in our criminal code for charging people who do that.
Fair enough. My thanks to Wendy Harvey, lawyer, and to Fran Grunberg, former director of the Child Abuse Team, MHR Counsellor on Sexual Abuse. Don't know if we've solved anything, but I would recommend anyone involved get a hold of this book. So you have to go to court. A Child's Guide to Testify as a Witness in Child Abuse Cases. Butterworth, Toronto and Vancouver. My thanks to you, Fran, for considerable help, and to you too, Wendy.
Thank you. And
I shall be back after the break. The Premier Van der Zam from Victoria tomorrow night. See how he feels about his first couple of months with the reins of office firmly in his hands. That should be interesting on Webster at 5 p.m. precisely. Stay tuned for Tony and the News Hour.